Good day to each and everyone. Today is I am going to present to you my report in the subject HRM6 Labor Relations and Negotiations, which is strikes, lockouts, and concerted actions. I am Monjo Viola and I am your reporter for today. So before we are going to proceed to our main topic, I would just like to present to you three articles of the revised penal code of the Philippine Constitution, the articles that mostly related to this topic that we are going to discuss today. So the first article states that Article 263 strikes, picketing, and lockouts. It is the policy of the state to encourage free trade unionism and free collective bargaining. So, what is a trade union? A trade union, oftentimes simply referred to as union, is an organization of workers who have come together to achieve common goals, such as protecting the integrity of their trade, improving safety standards, and attaining better wages, benefits, and working conditions through the increased bargaining power wielded by solidarity among workers. Ano naman ang free collective bargaining? According to the definition, it is a formal discussion between workers and employers about pay, working hours, and etc., which are not limited by the law or the government. So that's the Article 263. The other article that I am going to share to you is the Article 264, which is the prohibited activities. No employer shall use or employ any strike breaker, nor shall any person be employed as a strike breaker. So, ano ba yung strike breaker? Strike breaker, known pejoratively as scabs, are workers who have continued to work during ongoing strike action. Or it may be an existing workers, those who drafted in to plug the employment gap when other workers are striking, or those who cross picket lines in order to engage in employment. So they are also called as blackleg, scab, or rat. Then, Article 265 or the Improved Offer Balloting. So, kailangan ko siyang basahin ng mabuti para maintindihan niyo siya. It is an effort to settle a strike. The Department of Labor and Employment shall conduct a referendum by secret ballot on the improved offer of the employer on or before the 30th day of the strike. When at least a majority of the union members vote to accept to improve the improved offer, the striking workers shall immediately return to work, and the employer shall thereupon readmit them upon the signing of the agreement. So, in this case, if in order for the strike to not happen or para yung strike ay hindi maganap, kinakailangang makisali ang government or the Department of Labor and Employment to provide a referendum, which is a secret ballot. Itong secret ballot na to, naglalaman to siya ng mga offering to improve the quality of service or management of the employer to its employees. That is why it will help a lot in maintaining peace and order in the organization to avoid conducting a strike. So, yun siya yung Article 265. Now, we're going to proceed to our main topic. So, the first term that I am going to discuss to you is the concerted action. From the meaning itself, concerted, meaning an activity undertaken by two or more employees by one on behalf of others, which means it is a collaborative effort of employees to make a cause or a movement that would adhere their interest and their ideas on how the management should work, especially when they are not, halimbawa kung hindi na sila napapakinggan ng mabuti ng kanilang mga employer, kaya nagkakaroon ng mga concerted action. Next is strike. So, strike is temporarily a stoppage of work by the concerted action of the employees as a result of an industrial or labor dispute. So, ito na yung maaaring, ang strike, it is like a problem, a mass problem that commonly faced by a particular set of organization, especially corporation, kasi sila yung mga nagkakaroon ng mga kanang numbers of employees exceeding to a maximum level. So, nagkakaroon ng concerted action or pagkakaroon ng strike if an employer does not provide any satisfaction to what the employees needs. Kaya nagkakaroon ng mga labor dispute and other issues or conflict that may cause a strike. So, lockout. Lockout naman, ito naman siya, in this term would be probably in the context of the employer. Sa pagkakataong ito, temporary refusal of any employer to furnish work as a result of an industrial or labor dispute. Dito naman, hindi na yung employee ang mag-stop ng operation ng isang organization, kundi ang employer mismo sapagkat nagkaroon nga ng strike or any other dispute or any other concerted actions made solely by the employees. Kaya nagkakaroon ng shutdown ng operation that leads to a non-profitable or unproductive operation in a particular time frame due to issues such as strikes and other prohibited activities in the organization. So the next topic that we're going to discuss is the internal union dispute. It includes all disputes or grievances arising from any violation of or disagreement over any provision of the Constitution and bylaws of a union, including any violation of the rights and conditions of union membership provided in these codes. So, dito naman, hindi kasalanan ng employer kung bakit nagkakaroon ng internal union dispute ang isang trade union sapagkat ito ay nangyayari lamang sa pagitan ng mga members ng isang union. So, yun siya yung internal union dispute. The next topic is about strike area. So, what is strike area? It can be a place through which an strike can be conducted, whether in establishment, warehouses, depots, plants, or offices, including the sites of premises used as runaway shops of the employer struck against, as well as the immediate vicinity actually used by picketing strikers in moving to and fro before all points of entrance to and exit from said establishment. Ito naman yung ginasabi natin na strike area kung saan nagaganap mostly yung mga strike activities, yung pagsa-stoppage ng mga work from a particular department. Hindi ibig sabihin ng strike na buong company na ang magko-close or buong company na ang magkakaroon ng strike because there are other instances na yung mga employee from a particular department, like for example, yung mga workers or employees na nagtatrabaho particularly sa marketing department. Pag hindi nila nagustuhan yung management doon, pwede silang magkaroon ng strike in that particular area of the department. Kaya nagkakaroon ng strike. So, yun siya. It doesn't matter of how big that kind of issue is that for as long as the strike is gross, therefore, strike is declared. So the next topic is characteristic of a strike. So the number one characteristic of a strike is that there must be an employer and employee relationship, di ba? Ano pang silbi ng pagkakaroon ng strike kung wala namang ganong klaseng relationship? Alam nga naman yung employee lang magkakaroon ng strike kung wala naman silang employer na mapagtutuan na ng kanilang pansin o ganun. The next is number 2 is the existence of a dispute, 'di ba? Bakit ka magkakandak ng strike kung ang operation naman sa organization or sa isang company is harmonious and doesn't have any problem at all? So the third characteristics is employment relation is deemed to continue although in a state of belligerent suspension. So according to the definition, belligerent is kalimot ko sa meaning. Basta ka ng yung ano god ang tawag dito? Yung okay, proceed na lang kasi hindi ko din siya. But I am trying to figure out these things. So number 4 is there is a temporary work stoppage. So nagkakaroon siya ng strike or strike na ang matatawag doon kung halimbawa yung mga employee hindi na sila nagiging present sa isang organization or sa isang department ng company, yung magkakaroon talaga ng stoppage of work or hindi na talaga sila nag-a-attend ng kanilang mga tasks and responsibilities. So number 5 is work stoppage is done through concerted action. Kung ang halimbawa ang yung group of employee na ang nag-decide na mag-stop na or mag-refuse na sila sa orders ng isang employer due to a strike. So, yun siya. Then last is, the striking group is a legitimate labor organization. In case of bargaining deadlock, it must be the employee's sole bargaining representative. Ano ba yung collective bargaining deadlock? It is the situation between the labor and the management of the company where there is failure in the collective bargaining negotiation resulting in a stalemate. So, after defining the characteristics of the strike, let us proceed to the grounds for lockout. So, number 1, collective bargaining deadlock. So, explain ko na yun siya kanina. Then, unfair labor practice. So, magkakaroon na siya ng lockout or yung employer magdi-declare na siya ng lockout if there is an unfair labor practice. Kung yung mga employee hindi na talaga sila sumusunod sa management protocols, sa mga orders, or sa mga standard of productivity or standard quality of performance of the employees, therefore, magkakaroon na siya ng lockout. Violation of the collective bargaining agreement must be gross to be considered as unfair labor practice. Ganun siya. Conversion doctrine. So, a strike may start as economic and as it progresses becomes unfair labor practice or vice versa. So, halimbawa, yung unfair labor practice, nagalala na siya na nagalala. Therefore, meron ng pagkakataon na magkakaroon na ng strike and vice versa. Halimbawa, pag yung nagkakandak ng strike, if there is something wrong with the management or there is something wrong with the employer, that is why they conducted a what they call ULP or the unfair labor practice. So, yun siya. Conversion, di ba? Convert. Then, when strike or lockout cannot be declared. So, paano ba natin masasabi na yung strike or lockout ay hindi dapat gawin or hindi dapat ikandak ng mga union or mga trade union? Number 1, violations of the collective bargaining agreement which are not gross. Meaning, yung pagkakasala naman is hindi naman siya gaano kalala or severe or what we call unacceptable na yung situation. Halimbawa, yung yung case ng pagkakaroon ng unfair labor practice ng mga employer is gross na siya or unacceptable na talaga. So, pwede ka mag-conduct ng strike. Pero kung hindi naman talaga ganun kalala, therefore, lockout and strike cannot be declared. The number 2, grounds involving inter or intra-union dispute. Halimbawa, ang pagkakaroon lang ng mga dispute or mga conflict ay sa loob lamang ng mga trade union. Therefore, hindi kasama doon yung mga employers sa mga nagaganap na mga problema na yon. In that case, there shouldn't be a strike or lockdown or lockout to be declared. Kasi diba, sabi nga sa characteristic, a strike or a lockout, there must be a characteristic of an employee and employer relationship. Then, number 3. I got one. When there is no notice of strike or lockout or without the strike or lockout vote. Ganun siya. Hindi ka pwede mag-declare ng strike or lockout kung wala namang notice. Hindi ka, yung mga trade union, hindi sila nag-notice or nagbigay ng notification or message sa kanilang mga employer na magkakandak sila ng strike. Number 2, kung hindi sila nag-conduct or hindi sila undergo through a strike or lockout vote. Therefore, strike or lockout cannot be declared. The number 4, after assumption of jurisdiction by the secretary. Number 5, after certification or submission of dispute to compulsory or voluntary arbitration or during the pendency of case involving same grounds for strike or lockout. Who may declare a strike? So, number 1, any legitimate labor organization. Number 2, any certified or duly recognized bargaining representative. Number 3, employer. If there is certified or duly recognized bargaining representative, any legitimate labor organization may declare a strike but only on grounds of unfair labor practice. So, hindi ko na siya explain kasi naka-indicate naman doon kung ano man meaning nun sa number 2. Then next is notice of strike or lockout. Number 1. In case of bargaining deadlocks, at least 30 days before the intended date of strike. Ito na yung mga notice of strike or lockout. Number 2, in case of unfair labor practice, at least 15 days before the intended date of strike. Number 3, in case of unfair labor practice involving the dismissal of a union officer which may constitute union busting, union may take action immediately after the strike vote or the submission of the result of the strike vote to the regional branch of the board. Number 4, yun lang pala, number 3 lang pala. Next is the contents of notice of strike or lockout. So, ano ba yung mga contents of the notice of strike or lockout? Number 1, names and addresses of employer. Number 2, an union involved. Number 3, nature of industry to which the employer belongs. Number 4, number of union members. Number 5, workers in the bargaining unit. Number 6, other relevant data. Number 7, in case of bargaining deadlocks, the unresolved issues, written proposal of the union, counter proposal of the employer, and proof of request for conference to settle differences. Number 8, in case of unfair labor practice, the acts complained of and the efforts taken to resolve the dispute. Action on notice of strike or lockout. Upon receipt of the regional branch of board shall exert all efforts at mediation and conciliation to enable the parties to settle the dispute amicably. It shall also encourage the parties to submit the Voluntary arbitration. The regional branch of the board may, upon agreement of the parties, treat a notice as a preventive mediation case. So, ano ba yung preventive mediation? It refers to the potential labor dispute subject for conciliation and mediation assistance. Subject by either or both parties or upon the initiative of the NCMB, or what we call the National meaning siya? Commission on kalimutan ko. During the proceedings, the parties shall not do any act which may disrupt or impede the early settlement of the dispute. They are obliged as part of their duty to bargain collectively in good faith and to participate fully and promptly in the conciliation meetings called by the regional branch of the board. A notice upon agreement of the parties may be referred to alternative modes of dispute resolution including voluntary arbitration. So, yun siya. Preventive mediation, the regional branch may treat the notice as preventive mediation case upon agreement of the parties. Strike or lockout vote. Approved by majority, number 1. Approved by majority of total union membership or by majority of the board of directors or partners. Number 2, by a secret ballot. Number 3, in a meeting called for that purpose. Kung bakit nagkakaroon ng strike or lockout. So, the question is, when labor may strike or when the employer may lock out its workers. According to the Penal Code, if the dispute remains unsettled after the lapse of the requisite number of days from the filing of the notice of the strike or lockout and of the result of the election, the regional branch of the board shall continue mediating and conciliating. So, yun siya. Prohibited activities during strikes and lockouts. Number 1. Strike or lockout without first having bargained collectively. Strike or lockout without the necessary notice being filed with the Department of Labor and Employment. Number 2. Strike or lockout without the necessary vote first having been obtained and reported to the Department of Labor and Employment. Number 3, strike or lockout after Department of Labor and Employment has assumed jurisdiction or the President or after certification or submission of dispute to the compulsory arbitration, voluntary arbitration, or during the pendency of cases involving the same grounds for the strike or lockout. Then number 4, knowingly participating in illegal strike or knowingly participates in the commission of illegal acts during a strike ground for termination of employment. Number 5, obstruction, impede, or interfere with force, violence, coercion, threats, or intimidation, any peaceful picketing by employees during labor controversies, or shall abet or aid such obstruction or interference. The number 6, employment or use of any strike breaker employed as a strike breaker. Number 7, bringing in, introducing, or escorting by any public officer or employee, including officer and personnel of the AFP or PNP or any armed person in any manner of any individual who seeks to replace strikers in entering or leaving the premises of a strike area or workplace of strikers. The number 8, or the last one, is to commit any act of violence, coercion, or intimidation while engaged in picketing or obstruct to ingress or egress from the employer's premises for lawful purposes or obstruct public thoroughfares must be pervasive and widespread or consistently and deliberately resorted to as a matter of policy. So, improve offer balloting. So, number one, in case of a strike, regional branch of the board shall conduct a referendum by secret balloting on the improved offer of the employer. So ano bang ibig sabihin nito? Improved offer balloting naman is ito yung ginagawa ng mga employer to seek an advice from the Department of Labor and Employment as to how the conduct should not be conducted. Therefore, the Department of Labor and Employment or the DOLE will give a referendum through a secret ballot that will provide a offering or improved offering to the employees so that the dispute shall be settled. On or before the 30th day of a strike, dito ang improved offer balloting dapat ginaganap siya on or before the 30th day of a strike. At its own initiative or upon the request of any affected party. Number 4, when at least a majority of the union members vote to accept the improved offer, the striking worker shall immediately return to work and the employer shall thereupon readmit them upon the signing of the agreement. Number 2, in case of lockout, the regional branch of the board shall also conduct a referendum by secret balloting on the reduced offer of the union. It also be conducted on or before the 30th day of the lockout. When at least a majority of the board of directors or trustees or the partners holding the controlling interest in the case of partnership vote to accept the reduced offer, the worker shall immediately return to work and the employer shall thereupon readmit them upon the signing of the agreement. So ano nga ba ang power of the President under Article 263? So ang President may determine the industries which are in his opinion indispensable to national interest. Halimbawa, yung concern ng strike na yon is nag-trigger na ng public attention or national interest na siya. Number 2, may intervene at any time and assume jurisdiction over any such labor dispute in order to settle or terminate the same. So, ano mga ba ang mga consequences of illegal strike? So, good faith doctrine. A strike may be considered legal when the union believed that the respondent company committed unfair labor acts and the circumstances warranted such belief in good faith, although subsequently such allegation of unfair labor practice are found out as not true. So, yun siya. Rule on wages of strikers. General rule, strikers are not entitled to their wages during the period of a strike, even if the strike is legal. Exception, in case of an unfair labor practice strike, in the jurisdiction of the authority deciding the case where the strikers voluntarily and unconditionally offered to return to work but the employer refused to accept the offer. Example of an unconditional offer is we will return tomorrow and not willing to return provided. They are entitled to back wages from the date the offer was made. Number 3, where there is return to work order and the employees are discriminated against, they are entitled to back wages from the date of the discrimination. So, ano naman yung rule on reinstatement of striking workers? General rule, striking employees are entitled to reinstatement regardless of whether or not the strike was the consequence of the employer's unfair labor practice. But there is an exception. These are the following. Number 1, union officer who knowingly participate in an illegal strike. Number 2, any striker or union member who knowingly participates in the commission of legal acts during the strike. So, yun lang po ang aking report with the topic strikes, lockouts, and other concerted activities. Thank you for watching. Bye-bye!